Structure. Constitution of India is basically federal but with certain unitary features. The majority of Supreme Court judges in Keswandra Bharti versus State of Kerala were of the view that the federal features form the basic structure of the Indian Constitution. However, there is some controversy as to whether the Indian Constitution establishes a federal system or it stipulates a unitary form of government with some basic federal features. Thus, to decide whether our constitution is federal, unitary, or quasi federal, it would be better to have a look at the contents of the constitution. The essential features of a federal polity or system are dual government, distribution of powers, supremacy of the constitution, independence of judiciary, written constitution, and a rigid procedure for the amendment of the constitution. The political system introduced by our constitution possesses all the aforesaid essentials of a federal polity as follows. In India, there are governments at different levels like union and states. Powers to make laws have been suitably distributed among them by way of various lists as per the 7th schedule. Both union and states have to follow the constitutional provisions when they make laws. The judiciary is independent with regard to judicial matters and judiciary can test the validity of law independently. The Supreme Court decides the dispute between the union and the states or the states inter se. The constitution is supreme and if it is to be amended, it is possible only by the following procedure explained in Article 368 of the Constitution itself. From the above, it is clear that the Indian Constitution basically has federal features, but the Indian Constitution does not establish two coordinate independent governments. Both the governments coordinate, cooperate, and collaborate in each other's efforts to achieve the ideas laid down in the preamble. Judicial view. The question as to whether the Indian Constitution has a federal form of government or a unitary constitution with some federal features came up in various cases before the Supreme Court and the High Courts. But in most cases, the observations have been made in a particular context and to be, have to be understood accordingly. The question rests mostly on value judgment, that is, one's own philosophy. Peculiar features of Indian federalism. Indian constitution differs from the federal systems of the world in certain fundamental aspects, which are as follows. The mode of formation. A federal union, as in the American system, is formed by an agreement between a number of sovereign and independent states, surrendering a defined part of their sovereignty or autonomy to a new central organization. But there is an alternative mode of federation, as in the Canadian system, where the provinces of a unitary state may be transformed into a federal union to make themselves autonomous. India had a thoroughly centralized unitary constitution until the Government of India Act 1935, which for the first time set up a federal system in the manner as in Canada, which is by creation of autonomous units and combining them into federation by one and the same act. Position of the states in federation. In a federal system, a number of safeguards are provided for the protection of states' rights as they are independent before their formation of federation. In India, as the states were not previously sovereign entities, the rights were exercised mainly by the Union. Example, residuary powers, citizenship, etc. The framers of the American Constitution made a logical division of everything essential to the sovereignty and created a dual polity with dual citizenship, a double set of officials, and double system of the courts. There is, however, single citizenship in India with no division of public services or of the judiciary. Residuary power. Residuary power is vested in the Union. In other words, the Constitution of India is neither purely federal nor purely unitary. It is a combination of both and is based upon the principle that, in spite of federalism, the national interest ought to be paramount as against autocracy stepped with the establishment of supremacy of law.